Hey, and welcome back to part 4 of the Disciplinary series. Today we've gotten to a stage where you've appointed somebody to oversee your investigation, you've been through the process to look at if suspension was required, and you've informed all of the team involved that you're dealing with what is and isn't going to happen. We're now going to take a slight jump forward. We're going to assume that your investigating officer has looked at all the various evidence that's available. He's sat down and interviewed the people and the team members that are applicable to the situation, and he's formed, if you like, his evidence pack. Your investigating officer is now going to take himself or herself to one side. They're going to sit down and they're going to review the information they have received. Again, completely impartial, completely independent, no preconceived opinions go into this as you are doing it. What you've received in terms of information from the people you've interviewed obviously is a very different situation. However, you need to form, if you like, a case or the story of what has happened from that information you have been provided with. So, you've sat down, you've reviewed your evidence. This is where you're going to call your disciplinary hearing, and you will be inviting obviously the person you want to speak to about the disciplinary issue. You're also going to inform that they are entitled to bring a companion with them. A companion can be either a trade union representative or another member of the business, and they're really there as a bit of moral support, obviously. The companion can speak to summarise during or at the end of the meeting though, so please be aware of that. With you, when you arrive in the meeting as the investigating officer, I would suggest you take potentially somebody, if you can, from HR. If you're using outsourced HR, such as ourselves, invite perhaps one of us along. We will sit and take your notes for you, which makes life incredibly easy. We will also act as a guidance for both parties if they're unsure about perhaps different information within the company handbook that relates to what you're talking about, or in perhaps some cases relation to the law. And it's always good as, if you like, a second pair of ears. During the meeting, you're going to hear any further evidence that comes out when you present your case to the person who's being disciplined or potentially being disciplined. You're then going to make a comparative. And the best way to do that is to take a break the meeting. Go to one side. It could be 10 minutes, it could be 24, 48 hours. It depends how long you need and how complex the issues are. Providing you're communicating, it can be a fairly sustained period. If you've got different arguments in your head you need to go over. You need then to form a decision on what you are or aren't going to do, and whether you are actually physically going to discipline, perhaps give a gentle warning to, or whether you're going to go guns all out and perhaps dismiss because that's appropriate or an appropriate level of action to the situation you are dealing with. So we've reconvened our meeting and you've informed person X that you're disciplining what the sanction was. From there, you're then going to inform in writing as well, obviously, as you should do with any communication exercise. 1, talk it over. 2, deliver the information. 3, deliver it in writing. The person being disciplined then has obviously the right of appeal should they wish to action it. And I'll cover that in the next video. Take care, see you soon.